All right, folks, welcome to chapter 6 and congratulations on passing the prior assessment. So let's do this, baby. Pause right now if you haven't read chapter 6. Chapter 6 is a little lengthy, has a lot of words in there, a lot of new terms, words you've never heard before, most likely, and that's why you want to dig through it and then only play this video when you've already gone through it, took the assessment in the book, and prepared yourself a little bit more, all right? So let's do this, baby. Let's do this. All right, estates and interests. That's what we're going to talk about, estates and interests. We're going to talk about how you have interest in real estate. We're going to discuss this term freehold estates and leasehold estates. Freehold estates and leasehold estates, okay? Under freehold estates, in fact, I think on the board we may have some stuff for you. Yeah, right here. Freehold estates, you have a fee simple, fee determinable life estate, and under leasehold for a period of time. Okay, so you may be confused right now a little bit, but think of it this way. Your ownership in real estate could be your usage, your interest in real estate could be through a lease. Leasehold estate specifically refers to renting, leasing real estate for a period of time. So my friend, Duda, for example, he is... Why are you guys laughing? I wanted to use your lease example. Okay, can I do that? So my friend Duda, for example, he is about to end a relationship with a landlord that was 8 years long. His interest in that address for 8 years was a leasehold estate. Make sense? Now he's going to go into a freehold estate where he owns a property. So I want to congratulate him for taking that step of homeownership. He moves from a leasehold estate to a freehold estate, and there's 3 specific usage, and a fee simple is the highest use and ownership of real estate, okay? And you're going to find this information right on page 74 and 75. The question becomes, what is fee simple, right? What is fee simple? So an estate in the category of fee simple is the highest type of interest in real estate recognized by law. This is when you own the property forever. It's yours. There's no restrictions. You can do whatever you want with it. You have the highest usage of that property that you own, okay? So that's fee simple. What is fee determinable? So in New Jersey, a fee determinable is an estate in land that can terminate on the occurrence or non-occurrence of a specific event. For example, I can sell a piece of property to my friend Duda and say that this is going to be yours as long as you don't sell alcohol. As long as you don't sell alcohol in that property, you could own it. As soon as Duda sells alcohol, that property reverts back to me. I'm trying to help you understand these 3 different ownership styles. The first one is the highest. It's your property, no conditions. Fee determinable, the second one, is you have ownership in a property, but there is an occurrence that could happen that could void all of it, or a non-occurrence for that matter. There's an example in the book where John Smith conveys 1,000 acres to the Jones Foundation so long as it maintains as a wildlife preserve. 5 years later, the Jones Foundation decides to build its corporate headquarters on that land. And they messed everything up, I guess, because now title and ownership to that land revert to the Smith heirs. All right, so that's the second form of freehold estates. The third form is life estates. Life estate is pretty interesting because a life estate is limited to the life of a specific person. The owner of a normal life estate does not have the right to pass ownership to heirs. The idea is you own it for a life. Maybe your life or maybe someone else's life, but it's owned for a life. So you can't pass it down to anyone. And here's an example. Alan gives a life estate to Betty as long as she lives. Upon Betty's death, the disposition of the property is governed by Alan's original conveyance, right? So if Alan maintained a revisionary interest, the property will revert to Alan and his heirs. Let me pause for a second and summarize it in a simple way. I sell the property that I have to my friend Duda, and I sell it in a way where Duda could only own it throughout his lifetime. So there's a different value to it now, right? But I could sell him a property where he owns it. He could mortgage it. He could lease it if he wants to lease it and make money off of it. But he only controls that property throughout his life. Upon his death, it reverts back to me. Okay, there's more to it that you could see on page 75. So dig deep into life estates on page 75. Now, what else is there to real estate, right? So there's the form of interest that you have. It's freehold estate or leasehold estate, right? You could own it or you could lease it. And when you own it, you could own it with the highest degree in a fee simple, or you could own it determinable with some conditions, or you could own it for a certain life, for a lifetime, and then you can't share it with heirs. It would have to revert back to the owner. Now that we discussed that, how about this fancy word called encumbrances? Have you ever heard of the word encumbrances? Not too many of us hear that word. Even in real estate, we don't even use that word often, but that's the type of book we're studying, and that's the type of exam we're going to be taking. So we need to break down these words, get an understanding of what's in there, and I can't sit here for 75 hours a chapter giving you this. We have 75 hours for the entire book. So we really rely on you to do your part of reading and studying. So what are encumbrances? So encumbrances are what? What are they? They're pretty much a claim on to your property. An encumbrance is a claim, a lien, a charge, a liability attached to and binding on real property. And there's two different types of encumbrances. One of them is liens. Those are encumbrances, liens. So like mortgage liens, construction liens, tax liens, even judgments are liens. And we'll get into liens in a minute. But also there's physical and usage encumbrances as well. And these encumbrances include restrictions, easements, licenses. They're pretty much claims and restrictions, limitations on the property. So let's first tackle liens. And I'm going to do that little by little, and then we'll move quickly after that. But first, I want you to understand that there are involuntary liens and there are voluntary liens. Okay, involuntary and voluntary. When you go and apply for a mortgage, right? When you go and apply for a mortgage to purchase a home, the lender is going to put a lien on the house, but that is a voluntary lien. This is something you applied for. You asked the bank to have a lien on your house to protect their money. That's a voluntary lien. An involuntary lien is if when you don't pay your credit card and the collection company tries to get it, they can't get it, right? Then eventually the court gives a decree that you owe this money to the credit card company. That's called a judgment. And then the judgment puts a lien on your property. And now you got to pay that bill before you sell the house. If you want to go ahead and sell your house, you got to pay your mortgage. But wait, there's a judgment for $4,000. We got to take care of that first. And the title company will make sure they do that on behalf of the purchaser so the purchaser could buy that house without any liens. All right? There's those voluntary liens, there's involuntary liens. There's also general liens, and there's specific liens. I'm going to use the same example of a mortgage and the same example of a judgment. A mortgage is a specific lien. A specific lien is specifically for that one property. So you get a mortgage on this house, right? If the house goes into foreclosure, if you can't pay anymore, they will get their money from that property and only that property. That's a specific lien. A judgment, however, is a general lien. Whether you have a property or not, it's a judgment and it's a general lien, so it could hit all of your properties. You could have 4 or 5 different properties. It will be on all of them. It will appear on all of them. It's a general lien attached to your name. Whether you own a property or not, you have to eventually take care of that bill. If you win the lottery, the state is not going to release that money until they check if there's any liens against you. If you burn a house down and you get charged with that crime and a judgment is placed on you for $600,000 for doing that crime, you go ahead and win the lottery or run into some kind of inheritance or anything. A judgment allows for that reward for the party to get that reward. A judgment rewards the party that complains, right? And that judgment is general. So whether you have a house or not, it's going to come after you. It could eventually garnish your wages. All right, so that's an example of a general lien versus a specific lien like a mortgage or a home equity line of credit. That's usually a specific lien to that one property. All right, now that you got an idea of the type of liens, let's keep moving through this process. On the top of page 76, there's figure 6.3 on specific liens, and there's examples of them. So a utility lien is specific, a special assessment lien, right? Your tax lien, your mortgage lien, your construction lien, and a vendor's lien. Those are all specific liens for that property, okay? I want to touch on the word priority, the priority of liens, okay? This is important for your understanding. The priority of a lien determines the order in which debt will be paid off in the case of a foreclosure. I don't know if you've heard of the term first lien position. Lenders strive to be in first lien position. First lien position means they're the first lien, I should say, and they're a loan that you have against your home. Let's say your home is worth $400,000. You borrow $300 to purchase it and put $100,000 down. That's in first lien position. Usually it's your purchase loan. Now you go out and get a second loan 4, 5, 6 years later or 10 years later. The balance on that $300,000 loan is now down to $225,000. You want to take out a second loan because you have this equity, right? You now have $175,000 in equity, and maybe the market matured a little bit and you have a little more than that. You want to take out a second loan against your house. You have the equity, so you go ahead and get a home equity line of credit or a home equity loan. When you get that second loan, it's in second lien position. Let's say you withdraw $50,000. That is in second lien position. That's important because in case of a foreclosure, the first lien position has to be satisfied first. Then the second lien position, then the third, and they go in order. Now, I want you to note that taxes take priority over every lien. If you don't pay your taxes, it doesn't matter how big your mortgage is. The government is going to take their money because it's essential to running the government, right? To keep our firefighters and our police officers and our city workers and our state workers and our federal government running. The government relies on collecting taxes, and when it comes to your taxes on your house, it's the most important thing out of every lien. You need to note that. It's a priority. Let's highlight mortgage liens on page 77. You're familiar a little bit with a mortgage lien. I talked about it briefly. Did you know also there's a construction lien? Let's suppose you go ask a company to put windows up for you. They put the windows up for you. They order them, they install them, and the check you gave them for the down payment of $10,000 bounced. The work was already done. You owed them another $10,000 because the total work was $20,000. And now they're out of their money, but the windows are up. What does that company do? Are they going to go break your windows? Are they going to go try to rip up the... No, they're already fixed to the property. They're yours. They can't go back and take their windows. They took personal property, installed it on your real estate. Now it's part of your real estate. They can't retrieve it. But they could put a construction lien on your property. And that lien backdates to the day you signed the contract or the date the material was delivered, or the, I should say the date of the labor was provided or the material was delivered. So it backdates and takes priority as of that date. So that's a possibility. So be careful. If you're someone who wants to screw over a contractor, be careful. They will put a lien on your house. We touched on judgments. You could highlight that on page 77 as well. A judgment is a decree issued by a court. A judgment becomes a general involuntary lien on a real property owned by the debtor when it is docked or filed with the county clerk. So once a judgment is issued, it needs to be filed with the county clerk. And once it's there, it becomes a lien on property. Now, there is a process I want you to be familiar with that will be on your state exam called a les pendens. Okay, it's on page 78. Essentially, if you miss payments on your mortgage, let's use mortgage as an example. If you miss payments on your mortgage and it looks like you're in default of your contract, maybe you're going to be able to get a lump sum of money 3 months later and pay it all at once. Let's say your mortgage payment is $2,000 a month and you're behind on it 1 month. You're behind the second month. You're behind the third month. Now you owe $6,000 plus penalties and fees. Maybe in the back of your head, you're like, but I have this check coming in and I'm going to take care of it. Okay, great. But a lender wants to go into foreclosure. And to go into foreclosure, and they may not be able to foreclose in 3 months. They may not be able to foreclose right away. So they file this thing called the les pendens, which pretty much creates a cloud on the title. What it does pretty much is it informs potential buyers when they run title that although there's no lien on this property yet, there could be one. They may not be able to foreclose in 3 months. They may not be able to foreclose right away. So they file this thing called the les pendens, which pretty much creates a cloud on the title. What it does pretty much is it informs potential buyers when they run title that although there's no lien on this property yet, there could be one, right? If there's no foreclosure on this property yet, there could be one, right? So it gives notification to anyone who has interest in the property that something may be wrong. You need to clear it up. It's like heads up, all right? That's on page 76, and that brings us into easements. Before we go into easements, we're going to take a 5-minute break and come right back. All right, guys, welcome back. Remember when we started, we talked about encumbrances, right? We talked about encumbrances being in forms of liens or physical and usage encumbrances. All liens are encumbrances. So all liens are encumbrances, but not all encumbrances are liens. There's this usage and physical encumbrances also placed on the properties. And what are they, right? So there are easements. There's easements. There's encroachments, okay? There's deed restrictions. Those are other encumbrances that we referred to earlier. Now, in the interest of time, on the bottom of page 68, and also follow figure 6.6, also on page 68, and go through these different types of easements, okay? There's easements, there's an easement, appurtenant, easement in gross, easement by necessity, easement by prescription, which I think is crazy, which I'll get to in a sec. There's party walls. You want to get involved in creating, understand the creating of an easement and a termination of an easement. Okay, that's on easements alone. I want you to dig into that, and it's right there between pages 68 and 69. But real quick, did you realize that you could get an easement by prescription? So what is an easement? Let's start with that. What is an easement? A right acquired by one party to use the land of another party for a particular purpose. So the right that someone has to use somebody else's property for a purpose, that's called an easement. So there's a particular one that catches my attention all the time, and it drives me crazy, but in New Jersey, you could do it. It's called an easement by prescription. Now listen to this. This is on page 79. When someone has used another person's land for a certain period of time as defined by state law, an easement by prescription may be claimed. Now in New Jersey, this prescriptive period is 20 years. So listen to this. The claimant's use must be continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. Also, the use must be visible, open, and notorious. Now, if I start to mow the lawn of my neighbor every single week, week after week, and I mow the lawn in the backyard, because I have to mow my lawn and I just go. They didn't ask me to do it. They didn't stop me from doing it. If I do it continuously, open, in public, I don't care what anybody says, I'm just gonna do it. I'm gonna do it. I'm gonna do it. I'm gonna do it. And I do it for 20 years. I could claim that piece of land through an easement by prescription. It's crazy, but I could be stopped prior to the 20 years if the owner writes a letter giving me permission to mow their lawn. If they write a letter giving me permission and we have an agreement, then, I don't qualify. Right? This one catches my attention. I thought it would blow your mind that that's possible. That's an easement by prescription. It's crazy. All right, what else? What other encumbrances are there? There's licenses, right? So a permission to enter a land of another for a specific purpose is a license. Okay, it is not a permanent right and may be withdrawn. Examples of a license includes permission to park in a neighbor's driveway and permission to erect a billboard. Licenses may be written or oral. I may have the licensing rights to put a billboard on your roof. You may give me that. It's not something that I have forever, and you could take it back, But usually these licenses are granted and there's fees involved, but that's another encumbrance, a license. Encroachments. I like this one because I just recently had my backyard or my fencing done in my house that covered the backyard, my side yard. And it was a pretty long fence that we had to do. So to do it right, this is a fairly new home that we purchased. I went ahead and got my survey. I got a surveyor to give me a survey. The survey shows that the old fence that I had actually was encroaching on my neighbors by about 12 inches or maybe 18 inches on my neighbor. My fence in the back wasn't encroaching on anybody's property, but I realized that my neighbor was encroaching onto my property because my fence wasn't deep enough. I lost some, but I gained some, but I wanted to make sure I do it right. I reached out to the neighbor next door. I spoke to the neighbor next door. I spoke to the neighbor in the backyard. I showed them my survey. I told them they're entitled to get their own surveys as well. But my crew's starting and I want to make sure they're aware of what's about to happen. So one neighbor, like their backyard shrunk a little bit in one little section. And then the other neighbor kind of got an expansion to their backyard. But both neighbors appreciated the honesty. That's how you know where your property line is. When you get a survey, you'll see where your property line is and you'll see if someone is encroaching on it. It could be that someone built a shed and a piece of that shed is in your property, right? So that's an encroachment and you could go about having that person remove that structure off your property. What other encumbrances exist? Deed restrictions, okay? Deed restrictions are restrictive clauses. You'll see that in chapter 9. 3 more chapters from now we'll talk about that. But believe it or not, deed restrictions are restrictive clauses that are added to a deed when you buy a property. And it could actually restrict the owner of using that property. For example, there could be in the restricted deed a clause that says this property cannot go above 2 stories. Do you want to buy a property that restricts you from going above 2 stories? I mean, it's not restricted by the city. It's not restricted by the state or by the federal government. No one's restricting it other than the prior owner, restricting new owners from not going over a certain height. You'll see that in developments, in larger community developments, right? Where people are buying townhouses. They don't want the owner of a townhouse to all of a sudden put a high-rise next door in a community full of townhouses. So there's appropriate uses for that. But there could be silly uses to that as well, right? So you want to know these things up front when you're buying a property. So that's an encumbrance as well. A deed restriction is one. So let's go ahead and do the summary and send you guys off to get ready for this chapter 6 assessment, okay? Here we go. An estate is the amount and kind of interest a person holds in land. Freehold estates are estates of indeterminable length. Less than freehold estates, or what we call leasehold estates, are those for which the length can be accurately determined, like leases, for example. These are called leasehold estates and they concern landlords and tenants. Now, freehold estates are further divided into fee estates and life estates. Estates of inheritance include fee simple and fee determinable estates. Life estates can be granted for the life of the new owner or the life of some third party. At the end of the life estate, ownership can go back to the original owner, reverter, or pass to the designated third party, remainder. The rights of dower and courtesy ceased to be created in New Jersey as of 1980. Currently, the only individually owned real estate that does not require a spouse's signature to release remaining rights is property acquired after May 28th, 1980. That is not a family's main residence. Encumbrances. against real estate may be in the form of liens, deed restrictions, easements, licenses, and encroachments. Liens are financial claims against a parcel of real property. They are either general, covering all real and personal property of a debtor's owner, or specific, which covers only the specific parcel of real estate described in the mortgage, tax bill, building or repair contract, or other document. With the exception of real estate tax liens and construction liens, the priority of liens is generally determined by the order in which they are placed in public records of the county which the debtor's property is located. Now, mortgage liens are voluntary, specific liens given to lenders to secure payment for mortgage loans. Construction liens protect general contractors, subcontractors, and material suppliers whose work enhances the value of real estate. A judgment is a court decree obtained by a creditor, usually for a monetary award for the debtor. Les pendens, or a notice of pendency, is a recorded notice that a lawsuit is awaiting trial in court and may result in a judgment that will affect title to that parcel of real estate. Now, federal estate taxes and state inherited taxes are general liens against a deceased owner's property. Liens for water charges or other municipal utilities, surety bail bond liens are specific liens, and corporate franchise tax liens are general liens against a corporation's assets. IRS tax liens are general liens against all property of a person who is delinquent in payment of income tax. An easement is the permanent right acquired by one person to another's real estate. A pertinent involved two separate owned tracts. An easement in gross is the right such as that granted to utility companies to maintain poles, wires, and wire lines. Easements run with the land and are binding on future owners of the property. An easement by necessity can sometimes be acquired to gain access to real estate that would otherwise be landlocked. An easement by prescription, a permanent right to use land, is sometimes granted by courts when the land has been used by a non-owner for 20 years and certain other requirements have been met, which we discussed earlier. Now, easements may be created by agreement, express grant, or reservation in a deed, implication, necessity, prescription, or party wall agreement. They can be terminated when the purpose of the easement no longer exists by merger of both interests in an express intention to extinguish the easement, by release, or by an intention to abandon the easement. A license is permission to enter another property for a specific purpose. A license usually is created orally, is of temporary nature, and can be revoked, just like parking in my neighbor's driveway. An encroachment is physical intrusion on some improvements upon another land. And that's it, guys. This is the summary of chapter 6. I hope you got yourself ready to take the assessment. I know you'll do well, and I will see you on the other side. Remember your homework. We're going to be going into chapter 7 next. Make sure you get some rest. Make sure you're ready. And we're going to tackle chapter 7 next. Just do your homework, take that test, grade yourself, and I'll see you on the other side.